taught and trained to provide courts in this country. And again, this is the second time in less than 48 hours he's openly been critical of Your Honor, and without foundation. In both instances, he has affirmatively misled the public as to what is going on here. And this has been a pattern of disinformation from the beginning of this case. It obstructed the GBI investigation. It has obstructed the defendant's quest for justice. It is obstructing the administration of justice. With all due respect, if the court can't come up with some way to fashion a remedy here, I suspect the defendants will be back with much more dramatic requests tomorrow.
From the state.
Thank you, Judge. First off, it appears that Mr. Goff's exhibit number 2 is undated. The other exhibits all appear to be, map data from 2021. That's exhibit 1. We have exhibit 3, August 2020, and exhibit 4, October 2019, all from Google. And then we have this photo, exhibit number 2, no date or time on it. Mr. Goff asserted that he wants some sort of restrictions about what's going on around the courthouse. So all of his other exhibits are completely and utterly irrelevant to that. This is social media posts and complaints about Mr. Merritt. State's kind of befuddled as to how social media posts, which people may or may not look at, a tweet people may or may not pay any attention to, has anything to do with his request about restricting assembly outside of this courthouse. And of course the state wants to be very, very clear. Mr. Merritt is not a member of the Cobb County District Attorney's Office. Mr. Merritt is not seated at this table, and the state has absolutely nothing to do with Mr. Merritt and does not tell him what to do, and he doesn't tell us what to do. So conflating those two things is inappropriate and not relevant here. However, I did want to point this out to the court so that the court is aware of this. Mr. Sheffield, on October 6th of 2021, went on a radio program here in Glenn County, Scott Rifen. I think it was about a 40-minute kind of talk where he basically kind of advocated the same sort of thing. And it was done not in violation of your order, but in a way to please come to court, please say these things, please be honest with us, please tell us this, please do your civic duty.
The statement was be honest with us,
right.
Not say a particular thing to get on the jury. Let's be very clear if you're going to use that product. And that you were invited to come as well.
I understand that. The state declined to come. The state did not feel that it needed to tell the jurors of Glenn County what their civic duties were. But that is available on iHeartRadio with Mr. Sheffield basically putting out his position to tell the jurors what he thought they should come and do. So I wanted the court to at least be aware of what's good for the goose is good for the gander. To throw stones at one side shouldn't live in glass houses. In this case, the state really has no dog in this fight. What's going on outside this courthouse is beyond the prosecution's ability to control, because it is a constitutional right, freedom of speech and freedom of assembly. The court has placed a decorum order in place that monitors behavior, and we leave it to the discretion of the court to make the right decision. Thank you, Judge.
Final word, Mr. Goff.
Just to be clear, Your Honor, I've been on talk radio 1,000 times, but I was not a participant in that day's events. I can't speak to the content of. All I heard was secondhand. All I knew was I got a call. Did you hear what that lawyer did? I assumed he'd been shot, but fortunately he wasn't. But that is completely different than in substance. There is no way to get around the substance. of what Lee Merritt is doing. And what troubles me, Your Honor, is this isn't something new. This isn't something of a surprise or a shock. This has been something that the prior elected district attorney in Cobb County, Joyette Holmes, and her legal team has been well aware of from the start, because I have made it all painfully clear in numerous motions that were filed. And if nowhere does she address, and this is somewhat disappointing to me, nowhere does Madam Prosecutor address her duty as an officer of this court to seek justice and not merely convict. Instead of quibbling about the authenticity of exhibits, how about this? How about the GBI take 1/zillionth of the zeal that they've devoted to going after these three men and go check out those two interviews and get copies for the state to present to the court to review so the court can make its own judgment as to how big a problem this is. Because I don't have the capability of doing that. I paid for the premium subscription on YouTube and I still can't get it. Apparently you have to buy some special program, and through a bunch of cumbersome steps you can get somebody at the GBI. If they can do 3D drones and all this other fancy technological stuff we've got in this case, they can get these two videos. And I think the court needs to look at them. And let's bear in mind, Your Honor, that's what I can find on a Monday night, at 2 o'clock in the morning. We haven't even scratched the surface of what's out there on black Twitter and in the black media. We haven't even scratched that surface. And the further they get away from the mainstream, the more free Mr. Merritt and other people feel to comment more directly and in less, what's the word for it? Less ambiguous ways about what you're trying to accomplish. We have no way of policing that. The state does, and it's their obligation to ensure justice in this case. I would ask the court to direct the district attorney's office and the GBI to go look into this and report back to the court.
All right. The motion itself. The requested relief is to bar, as I understand it, signs or demonstrations within the area that Mr. Goff has defined here in the argument. Is that correct, Mr. Goff?
It is, Your Honor.
Let's focus on the motion itself, and then I'll address some of the noise going on. The court does not find that the movement has met its burden to limit the First Amendment rights of any individuals that may come to the courthouse grounds, which is a public place. I didn't ever hear any arguments with regard to the constitutional aspects of this First Amendment rights versus what may be happening here. I will note, because a lot of things have been noted, I will note when I came in this morning I didn't see anyone. In fact, it has been relatively quiet on the courthouse steps. There have been individuals that have come over the last week or so. I have checked in with the sheriff a couple times just to make sure that we have not been having any issues that should cause the court concern. No reported arrests, no issues again, and the demonstrations were not moved to what we'll just call the First Amendment zone, which was set up due to the fact that there did not appear to be any disruption outside the courthouse. Now, as to jurors coming in, a number of jurors have been asked about these signs or demonstrations, and I have not heard yet in jury selection, which has been thorough and sifting, that these influences that are claimed have occurred. And so at this point, the court simply finds that the movement has not met its burden on the motion to bar individuals and groups attempting to influence potential jurors. As to the what's going on, I'll call this noise outside the courthouse. A lot of this, in this particular case, the lawyers have been fully aware of, and both sides have participated in some way in some of what's been pushed out through the media, through interviews, podcasts, and a variety of other means. Now, I'm not going to suggest any, I'm not going to talk about intent or what that may have been, but both sides have done that. Both sides have been involved in raising the consciousness of the public as to what the issues might be in this case. And the court has put in place a couple of orders, one regarding the decorum in and around the courthouse, and the other being the order that restrains extrajudicial statements, and I believe under the circumstances of this case, both of those orders are appropriate, necessary, and appropriately tailored for the problems. Now, the issue I do have, though, and I will say this, it's interesting when we talk about the media and what the media are pushing out, and inside the well, what I hear everybody asking the jurors is whether they agree that what the media pushes out is not the whole story and may not be accurate, and in fact may be inaccurate. And now we're saying what's out there is a problem because of what the media is doing. It's a two-sided argument. And I will say this, though, that the media, as much time as we've spent in the last week and a half trying to coordinate with the media, there have been attempts by the media to comply with this court's requests to maintain anonymity with the jurors, to act with decorum in the court itself, in the jury assembly room, and outside. There has been general compliance with that I have been relatively happy with. And part of that has been some back and forth, particularly with regard to the court's concerns about the size of the community and the amount of publicity that's being pushed out, and how individual jurors, for example, may be identified through questions and other things. I will tell you, it troubles me significantly that any individual, separate from the lawyers in front of me here and the media, would be taking it upon themselves to create a narrative that does not comply with this court's clear wishes with regard to jury selection, identifying jurors, and using platforms to influence the public. That is a concern of mine. Now, how I'm going to deal with that, based on what's been brought to the court's attention, specifically the tweet that was just referenced, I need to think that through. Because again, with regard to the motion itself, the court's denying the motion. But my concern is, particularly with this tweet, that there are individuals out there that may be calling out specific jurors. I don't care what they have to say about me. That's not important. People are going to agree or disagree. People in this room are going to agree and disagree with the rulings of this court. That's the nature of the beast. So that's not what I'm referencing here. What I'm referencing is calling out individuals that may or may not be participating in this case in ways that attempt to influence the public and may, maybe indirectly, have an influence upon those members of the panel. I will work through that problem. But again, as to the motion itself, it's denied. Yes.
I just wanted to make sure I understood the court's direction of putting out any identifying characteristics or features of the potential juror is where I think that tweet becomes problematic. And I think that we're on the same page when that's specifically the type of identifying information that the court has already said do not disclose to the public. Is that correct?
That's what I instructed the media not to do. Yes. We also have the, I guess, well, it is a motion with regard to additional questions in voir dire. Ms. Hogue, or Mr. Hogue.
Your Honor, I take it the court did receive the email that my co-counsel sent, I believe last evening, that lays out the questions that we're interested in propounding with some law.
Let me ask this, though. They seem to be different than what we discussed yesterday, at least some of them.
I
understood the court asking us to either get rid of some or think about them and rephrase them in ways that might be smoother, and that's what it was.
and in fact, because this
Well,
is,
I only say that because I don't think I got it last night. I got it at 6:20 this morning.
yeah,
So we're,
It was about 11.
it's 11 and 46 seconds. It was sent last night from Laura Hogue to all the attorneys and to the court.
which address to the court?
Yeah.
No.
The address that we've been using. That would be. Apologies, Your Honor. And you can. Sorry. You're going to do an auto forward now, aren't you?
And because this is
I'm just, I don't know whether it got caught. I just didn't see it at 11. I got something, actually the response from the state at 6:30 this morning, so I didn't see it last night. But go ahead.
yes, and I will say, because this is such a fluid process, jury selection that is, this morning I have thought of another question that fits within the legal argument that we're making for the questions we've included in this email, and I would like to add that to the court's consideration. That additional question is this: would you be able to give fair, meaningful consideration to the defense of self-defense where the person killed was unarmed? And that's because I think it was yesterday, and we may have had another juror last week, who brought that up during voir dire to say how troubling it was to the juror that Mr. Arbery was unarmed and faced 2, possibly 3 armed men. We know that it was 2 armed men, but some thought maybe all 3 were armed. But that was a factor for a couple of jurors that could have made the juror not be able to give meaningful consideration to a self-defense claim if the one claiming self-defense is armed and the one we're claiming is the aggressor and who ultimately is killed is unarmed. And that makes sense. That's a legitimate concern a juror could have, and so we add that question to those that are included in this email.
Let me address that part of it first, since we're adding it in, and that way I won't forget about it. All right. The court has permitted the attorneys to get into whether or not the jurors, potential jurors, would consider defenses, and even specific defenses, and even gone as far as to allow questions, not just would you consider, but almost getting into going beyond just consider. Where I have stopped that is when we start getting into some more specific facts about the case and about the potential defenses. But I point out, and there's case law all over the courts. I'm just going to put it on the record at this point. Questions seeking to test prospective jurors' willingness to accept defenses or to identify jurors who are amenable to a particular defense are properly disallowed. That's Meeks v. State, 216 Georgia App, 630. It's a 1995 case, most recently cited, at least that I could find, in... Get to it, yeah. I'll just tell you where it's most recently cited that I could find. It may have been cited again since this. Recently cited in Stewart v. State. 262 Georgia App 426. Let's see. Stewart, it goes on to explain there's often a fine line between asking potential jurors how they would decide the case and questions that merely seek to expose bias or prejudice. The scope of voir dire, of necessity, must be left to the sound discretion of the court. And goes on to explain the Court of Appeals is not going to interfere with the discretion, absent manifest abuse. Goes on to talk about questions of technical and legal nature and questions that call for prejudgment are improper in voir dire. So as to these additional questions on defenses. The court's permitting the parties to get into consideration of the defenses, fair consideration of the defenses. The court's comfortable with where we are with that, so that will be the court's ruling on those questions.
All right, my apologies. Let me make sure I'm understanding what the court is saying. This is the ruling on the questions that we've included in the email.
This is the ruling generally. The court has already permitted the parties to ask about defenses and fair consideration of the defenses,
Right.
naming the defenses. Those have been asked. What I'm saying is there are limits, and so I'm not going to rule on additional questions. What I'm going to do is, if we go beyond where we've been with these jurors, if that's the intent, then no, if there's an objection, it's going to be sustained, because I believe the court has permitted, in fact, maybe even permitted more than would otherwise be permitted given the nature of this case, because the court has been flexible given the amount of information that is pushed out there or been pushed out there. In this particular case, I've gone farther than I normally would anyway. So what I'm telling you is the line is, you can ask them those questions about whether they'd give fair consideration to defenses, but we're not going to get any further into it, and there's support here for that.
And Your Honor, we do appreciate your latitude to us because of the nature of this case. And I want to concede on behalf of the defense that the line, and I'm quoting now from Ellington, the line between permissible inquiry into prejudice, which is then defined by the Supreme Court of Georgia as follows: a juror's fixed opinion that a certain result should automatically follow from some fact, regardless of other facts or legal instructions. Okay, the line between that, which is prejudice, and impermissible questions of prejudgment, and we have gotten many objections that we're calling for prejudgment, which is defined as speculation about or commitment to the appropriate result based on hypothesized facts. And then Ellington ends that sentence by saying that that line can be hazy. And it is. It's tough. And I want to assure the court that we on the defense side are trying to stay on the prejudice side of the line and not on the prejudgment side of the line. We're honestly not interested in laying out some facts in our case and asking jurors essentially, now how would you vote on that? What we're really doing is what Ellington itself says we're allowed to do when there are critical facts in a case that a juror might say when hearing them, that's it for me, that's all I need to hear. I don't need to hear any more evidence and any more law. And some of those facts in our case are ones that we've asked about. And the one I just indicated we'd like to add is, and again, this comes up in the course of conducting these examinations, and you begin to hear how these people are actually thinking and responding. And so it requires the adroit criminal defense lawyer to shift and change some along the way in response to what is occurring. And that's the nature of trial work. You have to be able to do that. So what concerns me, and I'm asking the court to make sure I am following Your Honor on this, is it sounds like we're being told that whatever we began the jury selection process with last Monday, October the 18th, those questions are the questions that now set the parameters of what we are allowed to ask. And I think I'm hearing the court say, and again, forgive me if I misheard, that if we go beyond that or ask a new question and it draws an objection, it will be sustained. I think I heard the court say. So if I was to ask this question today,
How could I? That doesn't make any sense to me.
well, again, I might have misheard.
Let me talk. If you ask a question and there's an objection made, I'll rule on the objection at the time. What I've said is that it's pretty clear what the parameters are here. I'm permitting questions about whether or not that the potential juror would consider defenses. Now, that's even a little bit further than some courts have said is okay. What you're suggesting is that additional inquiry needs to then occur. And what I'm telling you is that is potentially objectionable. Under the circumstances with that juror, if an objection is made, I will rule upon it, but I'm giving you what the court's position is right now. So, I mean, if you want to go ahead and debate it with any potential juror, make your record, but I'm telling you right now that the question that you proposed as additional questioning, for additional questioning, may be objectionable, and the court's told you where I'm getting that authority from, because I think it may go a little bit too far in this particular case.
And you're referring to the questions that we've included in this email, plus the one I just added?
No, I simply said you brought one more, one that's not even put in the email that you wanted to add in today. That's what I'm talking about. You started talking about the defenses and consideration of defenses and how you wanted to get into additional questioning on defenses. And what I did is I stopped you right there and said, okay, on that particular issue, let me just tell you where I am with the law, and we can just move on. And we can get back to what is actually before the, well, what was presented to the court last night.
Okay, what's in the email?
Correct.
Perhaps it would be economical to find out which of these questions in the email the state opposes or objects to, and then which one the court takes the position are not allowable no matter what the state says. That could save a little time.
It might streamline the process.
Yeah, I'm interested in that. And I know we're already looking at another 8 o'clock at night or later. So may I cede the podium to the state and let them say which parts of this they object to?
I have no problem with that.
And then I can come back up and address the ones they have objected to. And if they haven't objected to any of them, and maybe they'll object to all of them, then we have a better idea where we're going.
Mr. Domkowski.
Thank you, Judge. Regarding number one, I don't think there's an issue here. The defense has been asking these questions, and the state has not been objecting. I know at least 3 or 4 witnesses or jurors yesterday were asked, what do you know about Mr. Arbery? State did not object to that question. I'm not sure what the complaint is, and I don't want to call it a complaint here, but I believe that all of us here are asking these jurors, what do you believe you know the facts to be about this case? What do you know about Travis McMichael? What do you know about Greg McMichael? What do you know about Mr. Bryan? What do you know about Mr. Arbery? And then, you know, the question of how did that information impact your opinions, we're all asking them, do you have an opinion? The real question, of course, for the law is that opinion so fixed that you can't put it aside and base your verdict on the evidence that you hear between these 4 walls? So I think we're already asking all of these questions, so I'm not sure that that's an issue. With regard to number 2, you have supported the call for justice for Ahmaud. What are you calling for? The issue yesterday was we did have a potential juror who had said that they supported justice for Ahmaud. So asking that juror who has put that out there in their social media or even in their questionnaire, that's an appropriate question to ask them about what it is that they were calling for, what were they thinking about there. The state's objection yesterday was more towards a juror who had never put that out there, and the state just objects to the idea of planting the seed, suggesting things to jurors, getting them to talk about it simply to then be able to go, oh, well, we're going to strike them for cause because of their opinion about something that they never even said or brought up in the first place, but was suggested to them by the defense. So if a juror does say, I've supported the call for justice for Ahmaud, well, what are you calling for? What does that mean to you? The state is not going to object to that. We would object if it's asked of any jurors who have never said that or have never put that position out there. Moving on to the next question. The state objects to the question of, assume you have considered the evidence and the law at trial and were convinced that the defendants were not guilty. What pressure could keep you from voting not guilty, even if you thought it was what the evidence demanded? Given that pressure, would you agree that you are not a fair and impartial juror? This is the hypothetical that is not allowed. and the court this morning, both Ellington as well as Edenfield. In addition, I'm sure the court's aware, and I apologize, I handed the defense a copy of Willis. I have another copy, if I may approach.
Yes.
Of Willis. I've marked it for the defense and for the court. Willis says the court is aware it came out in 2018. And what we have from Ellington on page 13, of course, is Uniform Superior Court Rules on voir dire. It's 10.1. Hypothetical questions are discouraged, but may be allowed in the discretion of the court. It is improper to ask how a juror would act in certain contingencies. That's exactly what this question is. If this, then what about this, what about that? And it's improper under the Superior Court rules to ask this question. It's also improper on a certain hypothetical state of facts. No question shall be framed so as to require a response from a juror which might amount to a prejudgment of the action. And Judge, it appears that what the defense is truly trying to get at here is the question they are already actually allowed to ask. Here's your general questions. It is actually the last question. Are you concerned about your safety, reputation, or your livelihood if you were to be a juror on this case? The court allowed that question. That question really goes to, is there some pressure that you're going to feel to render a certain verdict? And I guess what the defense is trying to get at is, are you, I hate to phrase it this way, but asking the juror, are you so weak that you can't hold to your own opinions and you're going to let some outside force, not the other jurors, not the evidence in the case, but some outside family, professional, societal force cause you to render a verdict you don't believe in? And that is basically what they're asking here on 29. Are you concerned about your safety, reputation, or your livelihood if you were to be a juror in this case? And the follow-up questions have been all about the pressure. The defense has repeatedly asked, have you talked with your husband or your wife about this case? Have you talked with your siblings about this case? Have you talked with your children about this case? Have you talked with your friends and neighbors about this case? They've asked what those people's opinions are, and then they've asked, have those opinions affected your opinion? So they have gone well down that rabbit hole to determine if that juror has been influenced by family, friends, workplace people with their opinions, and they've been able to ask all of those questions. So this question, though, the state would object to because it is in violation of the Uniform Superior Court Rules 10.1 and Ellington. In addition, we find it also kind of goes with the Willis case on page 20, and I'm citing for the record to 304 Georgia 686 Willis versus the state from 2018. And there the court said, we find no abuse of discretion in the trial court's then forbidding sua sponte follow-up questions seeking to have a juror specify in which direction such a juror would be leaning, because the defense was entitled to only ask questions designed to reveal the prospective juror's general view on the critical fact, and in that case it was of a child murder victim, and whether that view on that critical fact, a child murder victim, was so strong that it would substantially impair the juror in considering all three sentencing options. So obviously this was a death penalty case. The court went on to say, we further find no reversible error in the trial court's later forbidding a repetitive question about the juror's ability to consider all three sentencing options. So Willis basically kind of reins in Ellington a little bit by saying, you can't ask about the direction. You can't ask, well, if you thought he was not guilty, what pressure outside would there be on you to come back this way? That's not allowed under Willis. To go ahead and talk about a critical fact, and they have talked about a critical fact. We've all been talking about the defenses of self-defense and citizen's arrest, and would the jurors be willing to consider those defenses? So we ask that that not be allowed. Then the defense also asked for a question, if you were on trial in this case, would you want a juror who held your current opinions and your life experiences. Why or why not? The only support that the defense has for that particular case they provided was the Irwin versus Dowd case from 1961. So this is a death penalty case, and the jury was not appropriately vetted in that case. And in addition, this is dicta. This part right here is the court going through, here are all the reasons you all did this really, really wrong in 1961. And the only line that the defendants cite to is the fact that while going through everything they did wrong, they also found this part wrong, which was a number of the jurors admitted that if they were in the accused's place in the dock and he was in theirs on the jury with their opinions, they would not want him on a jury. Notice the subtle difference here. A number admitted if they were in the accused's place, and I'll just pick Greg McMichael. If you were in Greg McMichael's place and Greg McMichael was on this jury holding your opinions, would they want Greg McMichael on the jury? That's actually what the question was asked in this case. So that's very, very different from what they're asking here. In addition, they're asking about who held your current opinions. The state has a problem with the current opinions because the current opinions are based on the news media, which we've all agreed is wrong, which is incomplete and is not the evidence between these four walls. So asking a juror, well, can you be fair and impartial based on your current opinions? Well, we've all been asking those questions. So the current opinions, which they've often said they can set aside and which are not based on the evidence within these four walls but on media, isn't really the way to ask that question. And then lived your life experiences. I believe this came up with, I know at least one, maybe two of our older African-American jurors who did indicate that they, throughout their lives, had seen some manner of discrimination, either by law enforcement, the criminal justice system, and some irregularity there. And so is this going to be based on the life experiences? Are they going to ask this of every juror, or is this specifically tailored to African-American jurors who have responded to the questions about their life experiences and any discrimination that they've seen? So we find this question to not be probative and not getting where the defense wants to go, which I believe would be, no, I can't be a fair and impartial juror, I wouldn't want me on the jury, or yes, I can be a fair and impartial juror, I want myself on the jury. But if they don't answer with either one of those particular answers, we end up down a rabbit hole, once again, of please defend your answer, please explain it to us, let's psychoanalyze your emotions around it, and the state, of course, would object to going down that particular rabbit hole. We've already covered number 3, which you have denied. And then, Judge, with regard to the question of are you aware of any impact that this case has had on Georgia law? There was a motion in limine that the defense agreed with, which we weren't going to go into the fact that this case resulted in some changes to Georgia law. Unless someone's a lawyer, and I'm not sure if you pulled a random lawyer off the street anywhere in the state of Georgia, they'd be able to tell you specifically what laws changed, even though they're lawyers, to ask these jurors about how the laws have changed. While some of them may know about it, what's the next question? Are you aware of any impact that this case has had on Georgia law? Yes, I'm aware. And then you're going to, well, what is that? What do you think the law is? Tell us all about that, as opposed to, can you put that impact aside and follow the law that Judge Walmsley's going to give you, which is what the next question should be, if they are even aware. The state objects to this because, of course, we've had a motion in limine to keep this out, and if jurors are now informed in this, basically, venue of, hey, the law changed, because I'm assuming this would be a general question, they would raise their card. Now we've told all 20 jurors, hey, this case resulted in the law changing. And
to be clear, I don't want to interrupt you, so we're on the same page. This is structured as additional individual questions, not general panel questions. None of them for the panel.
And we're not changing that.
well, my question then is, how would this come up an individual voir dire then. It would be asked of everyone individually, are you aware of any impact that this case has had on Georgia law? Once again, we're bringing it to the attention of every single one of the 20 jurors that this case has had an impact on Georgia law. The next question, if this is allowed, would be, can you follow the law that the judge gives you? Because at that point, the only distinction there is, it may have changed, but we're going to give you the law and you have to follow the law. So to bring this to their attention, we think is inappropriate, and we ask that you go ahead and not allow that particular question. I do understand that if a juror brings it up, a juror could sua sponte be talking about their opinions, and if they bring up the fact that they know the law has changed, there may be an appropriate avenue of inquiry, but the state would object to going deep into it, like, what do you know, what do you think? Because in reality, these jurors are the finders of fact. Okay? They are going to be instructed on the law, and they have taken an oath to follow the law that you're going to give them, and you're going to give them a jury instruction that tells them to apply the law that you give them, judge, to the facts as they find them to be. So it's really irrelevant that the law has changed. It's irrelevant that they know the law has changed or that there have been some changes. What's important is, are they going to follow the law that you're going to give them in regard to this case? We ask that you go ahead and not allow that particular question. Thank you, Judge.
Thank you.
And I didn't catch the state's response to the first set of questions. Those were okay?
I think the argument was that there are other questions that are asked and permitted that cover that questioning. And I don't mean to speak for the state, but that's what I understood from the argument.
Correct, Judge.
So the content is fine. We've been asking it in other ways, is what I'm hearing. Content, the subject of this first set of questions, asking jurors what they did hear or read about the case, what they did read or hear about Travis, Greg, we could add Roddy Bryan, or Ahmaud Arbery, and then how has that information that you read or heard impacted the opinions you have about what happened on February 23, 2020?
The whole entire point of the questionnaire was to get that question, and we have that answer. That answer is written out in a questionnaire that the defense wanted and advocated for and got. So repeatedly going up and then asking even more questions when they've gotten the answer in writing from the juror. Once again, we're in that area.
That's what I understood the state's argument to be.
Okay, so the objection to it is that it's already being asked in the questionnaire. It's already been covered. But we're talking about following.
You have a wonderful ability to restate things the way you wish to. I just heard the state's argument. You heard the state's argument. If you'd like to respond to it, you're welcome to.
Well, the best response to any argument is after you understand it, after you know what the argument is. And so when I restate a thing, I'm not trying to say what I wish I heard. I'm trying to say what I think I heard and ask, am I correct? And then I can respond.
I can't speak for the state. It's their argument. I'm listening.
Well, if the court's ruling on their argument, then I presume the court understands it and perhaps can help me out by
I'll go
telling.
ahead and rule on the motion. Go ahead and state your argument.
Well, the motion itself sets out why we want to follow up on question 2 from the questionnaire in this way. Question 2 asks, what do you believe the facts of this case to be? And it doesn't go into what else they heard or read and where they got this information, and then how their sources might impact their opinions or beliefs about the facts of the case. So that's the argument for that first set of questions. Moving on to the second question, again, I'm restating what I think I heard to make sure I understand correctly, that the state has no objection to question 2 so long as the juror has raised the issue by indicating they have participated in a Justice for Maud event or have expressed that in some social media posting or in any other way, even in the questionnaire itself if they happen to say it. or if we learn about it because they've given us their social media sites and we've looked at those and we see that they have liked, posted, forwarded, retweeted, or what have you, a Justice for Ahmaud or some similar sentiment. This question is merely designed just to ask, well, what is it that you mean by calling for justice for Ahmaud? So I take it that that question is not objectionable to the state, and therefore we ask the court to allow us to ask it and follow up on it. The next set of questions, it's still under 2. I've written in my notes I numbered it 3, but I shouldn't because there is a number 3 later. But it's different. It's the one concerning the pressure a juror might feel that would keep them from voting not guilty, even if they thought that was the proper verdict. I don't think anyone here would deny the possibility that a juror would feel pressure from any number of sources, from family members to the community at large or any other specific person they've encountered, to convict the defendants, even if they've heard the entire case and are deliberating and thinking, possibly, I'd like to acquit, but I don't want my city to burn. I don't want there to be business closures, and I don't want my own personal life to be impacted in some negative way. And there have been many jurors who've expressed that kind of concern to us. So this is just a way to follow up on that. And it's not asking, I think the state argued just now that it's asking them to act in a certain way. The word act was used. There's no action here being asked, no prejudgment being sought. It's asking what is resting on your mind, pressure, that could keep you from rendering a verdict you think speaks the truth, and yet you abandon it and speak falsely because of the overwhelming pressure you might be under to save your own business and your home and your city. That's all that question gets to. The last one on the bottom of the page, I don't have any further comment on it than what's in the motion. And now over on page 5, what we've numbered is question 3. I now want to correct my own misspeaking earlier when I said I was adding a question. I failed to look forward enough or remember that this is in here already. This is the question I indicated we wanted to add. It's just for those jurors who make a special note to refer to Ahmaud Arbery as an unarmed jogger, or say in some way, as one juror did yesterday, this is 2 armed men and 1 unarmed man, and that's what troubles the juror. And so, in fact, that juror, I think, did say it gives me difficulty in considering self-defense when you've got armed people versus unarmed people. And that's not unreasonable to wonder if a juror has that problem. And again, this is only if they make the reference to unarmed jogger, or in any way refer to the difference in power between the armed person and Ahmaud Arbery. And if they do indicate that, we simply want to be able to ask them if they are impaired, by which I mean, quoting Ellington, whether they have a prejudice, a fixed opinion that a certain result should automatically follow from some fact, regardless of other facts or legal instructions. What would that critical fact be? Ahmaud Arbery was not armed. And so we're asking them, are you unable to consider a legal defense when you learn a fact in this case, namely Ahmaud Arbery was not armed. The other questions, I'm not prepared to argue those. If I get Laura to help me, that could you meaningfully consider self-defense if the defendant didn't testify? And then, are you aware of any impact this case has had on Georgia law? Those two.
Your Honor, the response that the state had with respect to the impact on Georgia law was that we would somehow be suggesting that. But the question is, has already been, several jurors have already acknowledged their understanding of the changes that have arisen out of this case. Hate crime statutes that have now been passed, that jurors have indicated they think is a great idea and that they believe was as a result of this case. So what we are asking for is the opportunity to inquire into what jurors know, since there's been so much publicity, as I've set forth in this section of the memorandum, based on the front page reports in the AJC, linking the change in the citizen's arrest statute to Ahmaud Arbery and the situation at bar. The critical thing about citizen's arrest, Your Honor, as opposed to whether a hate crime has arisen out of this case, is that the characterization for the reason for overhauling the citizen's arrest statute was so that prejudicial things do not happen. So that this, as the governor said, replacing a Civil War era law ripe for abuse. So it is important that these jurors are specifically questioned about whether they're willing to apply a law that is now defunct. And there may be jurors, you're asking jurors in some instances, to apply a law that they would never have suspected would still apply in a case once the law has changed. So to ask some jurors who feel very strongly about citizen's arrest and very favorably about the legislative changes, it's important that they know what's actually being asked of them. And that's why, and because it's such an emotionally charged issue, because it arose out of this case, I have no intention of educating anyone. I want to know what they know so they can educate us, so that you can do the job necessary to decide whether that juror can be fair and impartial.
Okay. By the way, the email did come in at 11:12, so I did receive it. I just, for some reason, at 6:25 this morning was the state's response, and at that point I started looking at it. I didn't register the earlier version. So I did, basically what I'm saying is I did get that email, so.
Thank you, Your Honor. We sent it as soon as we could finish it up.
All right, so ask these questions. Question one, which is additional factual inquiry about Greg McMichael, Travis McMichael, and Ahmaud Arbery. Yeah, the court's allowing, well, actually, first there's a questionnaire which lays out the facts that the potential jurors believe to be the facts of the case. There are questions that are being asked about negative opinions about the defendants, who may know the defendants, who may know Mr. Arbery. As far as these specific questions, all of this is covered. The defendants are being permitted a thorough and sifting questioning of each individual. We're not going to go further than what is already being permitted, and that will be the court's ruling on the first question in the email that was sent at 11:12 last night. I'm just looking at any additional notes that I have. Yeah, no, I just had some, okay. So that'll be the ruling on that. Question number 2, which gets into, let's get to it. Let me just be clear for the record on question 2. Have you supported the call for justice for Ahmaud? What are you calling for? There is already a general question about Black Lives Matter. I don't know if it specifically references justice for Ahmaud, but in general questioning, we can go ahead and expand that question to include justice for Ahmaud. I run with Maud. I'm trying to think of the others that have come up during jury selection. If somebody thinks of one of those additional slogans, saying tags, let me know. But I don't have any problem adding that into general questioning.
Your Honor, what I think in the state read it the same way that I intended, which is if you had, they've indicated they support the call for justice for Ahmaud, and that's the only time that we would then be asking, well, what do you call it?
But I don't think that's included in the general questions. Let me take that thought one step further. Yeah, if they respond to that in the general questions, then go ahead and follow up.
Thank you.
But as far as bringing it up with every particular juror, I'm not going to permit that just as a individual voir dire for every single individual. All right, then going on with question 2, there are additional thoughts. The court's not going to permit these additional questions. Assuming you're considering the evidence in the law and we're convinced the defendant's not guilty. Again, the court touched on some of that with Mr. Hogue earlier on. Let me update, because I indicated that the most recent case I found was, I think, a 2003 case. Lester v. State, I think, is also helpful. Lester v. State, which is a 2017 case, because there's also a Lester v. State that touches on jury selection, which is a 2003 case. But Lester v. State, 343 Georgia App, 618. Georgia Court of Appeals had previously held the trial court does not abuse its discretion in refusing to allow questions designed to find jurors' willingness to accept a particular defense. So that just updates that. As to question 2, I'm not going to go further. This is prejudgment as far as I'm concerned, and the court's not going to permit it. There's also this question in what is proposed as to, if you were on trial this case, would you want a juror who held your current opinions and lived your life experiences, why or why not? I think the defense cited to Dowd. The court has read Dowd, and Dowd references a question that was asked in that case, doesn't analyze the question. It is referenced in the context of a separate legal analysis, and it's not clear that that particular question was thoroughly reviewed or vetted in any way by the court. It was acknowledged as being asked, which I guess you would presume then the court thought it was okay under those circumstances, but that was under the facts of that particular case. It being fact-specific, I don't think it, and given the way it's referenced in that case, I don't think it controls, but there's also, in the state of Georgia, I do point out Hayes v. State, 236 Georgia App 617. Hayes v. State, 236 Georgia App 617, which found, it discusses questioning of the jury, and says, thus, in a classic golden rule argument, the state cannot ask a juror to put themselves in the victim's place. Conversely, we have held that any argument that asks the jurors to consider the case not objectively as fair and impartial jurors, but rather from the biased subjective standpoint of a litigant would be improper argument. Citing to Myrick versus Stefano's 220 Georgia App 520. So there's a Georgia case that I think is much more closely related to what is being proposed. I do not think Dowd controls, and therefore that question will not be permitted. Question number 3. The court has already ruled or indicated its position when it comes to additional facts, when it comes to the defenses that are raised. And again, I've already provided guidance on that on a case-by-case basis. The court is not suggesting the defendants can ask whether or not defendants or the jurors, potential jurors, would consider certain defenses. It's when we start getting into specific facts of the case where the court has some concern and will consider objections from the state if they are made, if additional facts are inquired into. And then finally, this question of, are you aware of any impact this case has had on Georgia law? The court's going to permit the following, because the court's going to permit the following in general questioning. Will you follow the law that is given you by the court, even if you think the law may be or should be different? And if there's a response to that question, then you're welcome to follow up. Again, notice, will you follow the law that is given you by the court, even if you think the law may be or should be different?
And Your Honor, will you allow us to insert the word citizen's arrest, the law of citizen's arrest?
I don't want to get that specific in general questioning.
Not in general questioning. Okay.
No,
You
but
want
if there's
to
a-
add this to- I'm sorry, I didn't understand. Just want this for general
Yeah,
questions.
go ahead and add that to your general questions, and if there's a response to that in general questioning, then you can go ahead and follow up
So
on it.
I'll add that to our list.
Do you have that, Jason?
I just wrote it.
I wrote it down. Will you follow the law the court gives you, even if you
Think the law should be different.
think the law should be different?
Or maybe or should be.
Think the law may be or should be different.
Maybe the law should be.
So, Your Honor, will you be asking that particular question? No? So we did ask, I believe that question will modify, it was a follow the law question, and I think it was, is there anyone here who feels that they will not be able to follow the law? We will go ahead and amend it to this at this time,
In your general question?
in our general questions.
Yeah, it does not matter to the court how it's asked, but the court would permit the question.
Okay.
I'm not sure that made sense. It does not matter to the court who asks the question, but it will be permitted.
Your Honor, if I could have just the court's ruling on the question with respect to applying the law of self-defense in a situation where someone is shot and the person who was shot was unarmed. Under Ellington, I believe the court's going to need to rule whether you believe that to be a critical fact in the case, and if so, then you decide whether or not under Ellington we can.
Where is that question?
Well, that was the question number 3, Your Honor. I'm just making sure that we have perfected the record on this issue. We're asking for that question under Ellington. For jurors who say that Ahmaud was an unarmed jogger, could you meaningfully consider self-defense if Ahmaud Arbery didn't have a weapon? And that was question number 3 on page 5 of that memorandum. And I believe that I'm stating my understanding of Ellington, the court is ruling, it has a 2-part ruling, whether you believe that to be a critical fact for analysis and whether or not the defense can use it during voir dire.
Bear with me a second. See what the question was. sure I understand what you're suggesting the court needs to do under Ellington. And Ellington gives the court broad discretion in voir dire. I think there are a number of cases, I know there are a number of cases, some of which I have cited here today, addressing vetting a potential juror on potential defenses. Actually going as far as to say that that may be improper questioning in voir dire. And what I've said now at least twice this morning is that the court is permitting questions about whether or not the potential jurors would consider defenses. But once we start getting into facts and adding additional hypotheticals even into that question, then that is objectionable. So, would you give meaningful consideration, or I have already ruled that 3 is not going to be permitted. Again, you're adding in facts to a question about a potential defense. And again, the court's already cited a case law. And then again, could you meaningfully consider self-defense if the defendant didn't testify? Again, you're being permitted to ask about defenses, and the law is going to be given to the jury about the defendant's right not to testify. So, no, those questions aren't coming in, and I think the court's been very clear about that.
Yes, Your Honor. And to be clear, I'm not arguing with you about your ruling. I believe that in order to have a clear record, the court has to decide whether you believe the fact we're asking for to be specifically inquired under Ellington to the jury is in fact a critical fact in this case. And you can find yes or no, and if it's not, then of course you don't go to the second step. But if you believe it to be a critical fact, then the question is it allowable or not?
Ellington, I think, was a death penalty case talking about a change of venue.
Yes.
Okay, this is a different set of circumstances. I'm talking about other cases which address specifically a question asked by lawyers about defenses that are to be raised. Those cases are very clear that the court has the discretion to limit that. In fact, I've said there are cases out there that indicate we're probably beyond where some courts' discretion would cut this off. So, I mean, I'll look at Ellington to see whether or not it has a specific test that this court needs to go through. I didn't read it that way, and I think it's a different animal because, again, we're talking about a change in venue in that case, in a death penalty case. But I'll take a look at it to see whether that's the case.
Yeah, I would encourage that, Your Honor, because I don't think the main point of Ellington for our purposes here is any venue discussion. It is the critical fact issue in Ellington that instructs us and is the basis for this motion. As you might recall, in Ellington, it was the critical fact of the murder of 2 small children. And Ellington was not allowed to ask jurors about it, and the case got reversed because of that. And it has now since informed many cases, not just death penalty cases, and they cite several non-death penalty cases where, for example, in child molestation cases where the critical fact can be asked because, and the test is, if a juror is not told the critical fact, they might say, I can be fair and impartial given the charge of murder. And then when they hear an opening statement, as they did in Ellington, this is the murder of 2 two-year-old twin boys, jurors then say, had I known that fact, I would have answered no. I cannot be fair and impartial. That's all I need to hear. I'm done thinking about any other evidence you might have. So in our case, we're saying, because we are hearing it from some jurors,
you want to come in a little closer to me? Just, is that all right? Certainly. Does that work? Oh, no, you're on, you got an X. I apologize, that's right. I'm above my pay grade on this.